Good morning. This is Jen. My channel is The Liberty Lion. If you're a subscriber, thank you for being a subscriber. If you're not a subscriber, think about subscribing, liking, sharing, and commenting. This video is reference the jurisdiction over federal areas within the state. This is something that I've been talking about since the beginning of my channel. But I found another book on archive.org. This is an officer's manual from about 1917, which basically says the same things that Eisenhower said in the report that he had commissioned called Jurisdiction Over Federal Areas Within the States. But this is an officer's manual, and these officer's manuals go back since before the writing of the 14th Amendment. So being 1917, of course, you know, this is after the 14th Amendment was passed, which I believe is an unconstitutional amendment during the Lincoln administration to expand the perception of the federal government's jurisdiction, allowing people to believe that the federal government has jurisdiction off federal lands, which it does not. The federal lands are the seat of government and places purchased for forts. And in the Constitution, it says that the laws of the United States and the Constitution are the laws of the lands. And we know that those lands are the seat and the places purchased. So you have citizens of the United States that are on federal lands and state citizens that are off federal lands. And even if you apply the 14th Amendment, it does not make state citizens federal citizens. It only makes federal citizens also state citizens. And if you've been listening to my videos, you probably know that I don't believe that the 14th Amendment was properly passed or that it has any merit to it, because it was passed at a time when the country was at war with itself, and when the corporations had finally made their last stand to take over the federal government using Lincoln, a former railroad attorney. So I'm just going to look through this book. You can download it off archive.org. I will do my best to post a link to it. I'm sure that if you search through, you could find it. So what I did was I searched for the word citizen. So the militia of the United States consists of every able-bodied male citizen between 18 and 45 years of age. Now, a lot of people will read the Constitution and they'll say a citizen of the United States is the only citizen I see in there, so therefore everyone in America is a citizen of the United States. But that is misleading, because there are state citizens and federal citizens, because the federal Constitution was to give power only to the federal government. And so to become a federal citizen from the state, you had to leave the state and become a federal citizen. And those federal citizens were the ones that would go to the seat of government after a period of time serving in the state on the federal lands, 7, 9, and 14 years respectively for representatives, senators, and president. So these are citizens of the states because the militia consisted of privates, and the people of the state are considered private citizens. You cannot be both a private citizen and a public one. They claim that you can be a private citizen for some purposes and a public citizen for other purposes, and I say that that is not true, that there's no way that that can occur, because the whole purpose of being a public citizen was to be in the public at all times, scrutinized, as well as having whatever private business you operate scrutinized, because after the Constitution was written, there were a lot of public servants who were stealing from the federal government. And then they were leaving the federal areas and running into the states and hiding. And sometimes they were stealing bags of gold and silver, which was the lawful money at that time, according to the Constitution. And so they had to start making laws to regulate or oversee even private income by public people, which of course now we know they don't do anymore because they're all in on it. So the Reserve Militia, comprising of able-bodied male citizens between the age of 18 and 45 who do not belong to the organized militia. So you had an organized militia and you had a reserve militia. I encourage you to read this book. It's not very big. I wouldn't maybe read it cover to cover, but you can read it, search it, and read through some of these things on here. The use of the army in aid of the civil power. While any citizen as such, and this includes military persons. Okay, now it says citizen, not civilian. Civilians cannot be military. So while any citizen as such, and this includes military persons, may seek to quell a disturbance or riot and assist in preserving the peace or in the arrest of one committing a crime in their presence, no officer or soldier in his military capacity may do so excepting on a military reservation. Again, this book is written after the 14th Amendment, which made federal citizens also private citizens, or federal citizens also state citizens. So you had a military capacity on a military reservation in uniform. You have a military capacity in uniform off a military reservation. And then you have a regular citizen on and off military reservations, off military reservations, not in uniform. So basically, anytime a soldier is not in uniform and off a military reservation, he's a state citizen. And that just means he has to observe the state laws. Or she. They may do so excepting on military reservation or where the offenders are military persons otherwise than as provided in the Army regulation. Should conditions arise prompting action as provided for in paragraph 496 AR 10, the officer on whom the responsibility rests should very carefully consider the facts of the case and be certain that he is acting in accordance with the regulations referred to. So really, they prefer to keep military people on federal reservations and out of civil disturbances. The military forces of the United States cannot be used as a posse comitatus, nor can they be used except by the authority of the president for the maintenance of order in a state or for the upholding of the state laws. Where the interests of the United States are not involved, the military may not take action except under orders originating with the president. So the military cannot get involved in state issues unless those state issues involved issues with the United States. So in all these corporations where these corporations are pretending to have some sort of federal backing to force people into contracts with them to pay a tax that actually doesn't really go to the federal government, but yet they use federal forms to get people to contract with them. What power did they have if there's no military power off a military post? Only the police, which then brings into question who's really paying the police and who did the police really work for? And if Lincoln answered to the corporations, and if Lincoln was placed into the presidency by the corporations, did the corporations then, during the Civil War, basically take over the federal government when they forced the southern states back into the Union and forced the northern states to agree to be friendly to the Union? What union? The Union of Corporations? The corporations can't use the military, so they had to create a police to use the police to force people, to scare people into these contracts with them, because there are no forced contracts with the federal government. There is no right of the federal government to use contracts to get people in under it. If they had that right, if the federal government had the right to get people to pay federal tax, they wouldn't need you to sign a contract saying you were going to do it. In case of civil disturbance in violation of the laws of a state, a military commander cannot volunteer to intervene with his command without incurring a personal responsibility for his acts. In the absence of the requisite orders, he may not even march or array his command for the purpose of exerting a moral effect or any effect in terrorem. The root word for terror is terra, which is land. Such a demonstration indeed could only compromise the authority of the United States while insulting the sovereignty of the states. And the only way states have sovereignty is when the people create a state. So the people have to have some kind of sovereignty in order to create a state. Some people will say that sovereignty comes from the fact that they align themselves together to form one unit. And you have to have so many people to do that. So you have to have a majority. And according to the TM, I think 2025, democracy is the use of force or mob rule. But that's only when the democracy has no moral. Because in a moral society, you don't use mob rule. Military reservations. Now, this is something that we'll see in jurisdiction over federal areas within the states. There's two parts to this, published in 1956, part 2 in 1957. Even if you just read the first chapters of the first two reports, you'll get a really good idea about what we're talking about here. Military reservations. So a military reservation is called a post. So when it talks about post offices and post roads in Article 1, Section 8, it's talking about on military reservations. And it may also include the roads built between military reservations that are on state lands, called the highways, because highways is a word used for commerce, and commerce is also a word for traffic, and traffic, commerce, and highways are all used as words that describe wartime traffic, wartime commerce, wartime highways. So through the oceans where the ships travel, it's not just commercial commerce, but also military commerce. The Congress shall have the power to exercise exclusive, this is what it says in Article 1, Section 8, called 17, which I talk about all the time. And think about a fence around a military post, a military reservation, a base, an installation, all those things that we call them. In the Constitution, they're called posts or lands or places purchased or forts. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by cession of particular states and the acceptance of Congress become the seat of government of the United States. Okay, so you have the seat of government, okay, right there. And then after that, you have places purchased. So these forts have fences around them. The fence, on the top of the fence, there's usually a roll of barbed wire. The barbed wire faces towards the state, and that's because they don't want you in there. And we'll see that. There was a story when I was in boot camp of a little girl. She had ran off. Nobody had seen her. And the company commander came into the barracks and started yelling, has anybody seen her? Has anybody seen her? Nobody saw her. And she said, I'd just like to point out to you guys that, or gals, that the barbed wire on the top of the fence points out, and that's to keep the state people out, not to keep you in. If you want to leave, you can leave. You just have to do it right. You can't just walk off, because once you get on property and you become a public servant, a member, a citizen of the United States, you become government property. They're responsible for you. To exercise, this is where it talks about posts, to exercise like authority over all places purchased. Okay, now places purchased is an important phrase because you can acquire lands in different ways. Not constitutionally, but they have acquired lands in different ways. And on those lands, they have a different type of jurisdiction, not a military jurisdiction, not complete jurisdiction or like authority. To exercise like authority over all places purchased by the consent of the legislature of the state. So the state has to agree, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So those lands are supposed to be used for forts or other federal things. Under this section of the Constitution, the exclusive jurisdiction of the United States for legislation implies jurisdiction exists. I don't think it implies that. I think it just says it right out. Jurisdiction exists over all military reservations which have been purchased with the consent of the state legislature. This is also the case where the United States has reserved exclusive jurisdiction over a reservation previously established in an act of admission of a state. So when a state joins the Union, some of those states already had forts, and so they gave up their right to command forts, and it sold those forts to the federal government. A number of our military reservations, however, have been acquired in other ways. Where this has been the case, the states have generally ceded jurisdiction to the United States over the land composed in the reservation. The cession of jurisdiction, so giving up the right to rule. Cession of jurisdiction. So if I have a piece of property and I sell it to someone, I can cede all the jurisdiction over it, or I can keep some for myself, such as mineral rights. So what this is saying is that the cession of jurisdiction, so it's complete cession of jurisdiction over these areas. But some states reserved some things that it could do on the federal lands. For example, some states can serve process upon a military member on a federal reservation, and some states did not reserve that right, and so they cannot. The cession of jurisdiction differ in their terms and in their extent of the jurisdiction reserved to the state. So the state may have reserved mineral rights. The state may have reserved the right to serve process. The state may reserve the right to certain other things. In some cases, exclusive jurisdiction is granted. In others, the right to serve criminal and civil process concurrently with the United States is reserved. Again, as in Kansas, the right to tax railroads and corporations on the reservation is reserved. And finally, there have been cases where general concurrent jurisdiction with the United States has been reserved. Where this is the case, it has been held that the cession of jurisdiction was of no value to the United States. Of course, over reservations situated in the territories, the jurisdiction of the United States is paramount. And the territories, meaning the West, where the states have not been formed yet. Because the United States of America wanted to make sure that it kept those lands from being invaded by foreign forces. And so they had the reservation of, or they had the jurisdiction over those territories, at least until the territories were made states and joined the Union. In which case then the state would cede some lands to the United States for military purposes. All unauthorized persons coming on a military reservation are trespassers and may be removed by military force if need be, but the use of force should be no greater than is required to effect the removal. A post commander can, in his discretion, exclude all persons other than those belonging to his post, because they're called posts, post offices, postal roads were the military posts, and perhaps with the approval of the state, roads in between posts so that the military can travel from one post to the next, including from post to seat of government. And reservation grounds should he admit everybody except one individual against whom no charge of wrongdoing existed, such action would be considered an abuse of discretion on the part of the commander. So the commander cannot arbitrarily pick and choose who he allows on post and who he doesn't. It would be an abuse of power. So what about the people of January 6th? Are conservatives not allowed at the seat? Whoever shall go upon any military reservation, army post, fort, or arsenal. Now, it doesn't say seat. For any purpose prohibited by law or military regulation made in pursuance of law, or whoever shall re-enter or be found within any such reservation, post, fort, or arsenal after having been removed therefrom or ordered not to re-enter by any officer or person in command or charge thereof shall be fined not more than $500 or imprisoned not more than 6 months or both. So by reading this, we start to ask ourselves, so the seat of government is supposed to be probably open to the public where the forts are not, because the forts are for military purposes, for forts. The seat of government should therefore then be open to the public. Okay, that's cutting of trees. Trespassers are put off a reservation. They should not be allowed to take with them any property of the United States. And it talks about squatters. Because everything you read in the Constitution is for the regulation of the federal government and its places purchased for building forts, arsenals, dockyards, and other needful buildings. And then there are some things that the states agree not to do, such as make treaties. They leave that to a representative at the seat of government, a ambassador or a minister, which are civilians. And it's my opinion, of course, that if you've been listening to me, that the senators and representatives at the seat of government are supposed to be military officers. Because they're supposed to have their time in service before going there. where the United States, let's see, civil jurisdiction on a military reservation. So civilians on military. Now we know that civilians work on military posts. They are called civilians because they are not in the military. They are private people who go on military posts to do work to help the military do things that the military doesn't generally have office positions for. Or in some cases, these are people who have a special knowledge of something and are able to aid the government, the federal people, with some particular thing. Civil jurisdiction on a military reservation. Where the United States has exclusive jurisdiction over a reservation, the state laws do not run the fence, right? There's a fence. And no service of civil or criminal process may be had excepting such as proceeds from the federal courts. So civilians on military posts come under federal courts. I'm assuming that. Let's see. Where the United States has no exclusive jurisdiction and no cession of jurisdiction has been made by the state, the laws of such state run on the reservation as they do in all other parts of the state. So the legislatures have to cede jurisdiction in order for the federal government to have exclusive jurisdiction, power and authority over that place. If they don't cede jurisdiction, exclusive jurisdiction, the state laws apply on the federal lands. Now, one way they get around that are these corporations buy lands in the state and then cede them to the federal government. But that still doesn't allow exclusive jurisdiction. It only aids them in tricking people into believing they have exclusive jurisdiction, such as the Federal Reserve banks. They do not have federal jurisdiction on the lands that they purchase, even if they ceded them to the state. In this case, the service of process must be allowed except where such interference and jurisdiction of the state would destroy or impair the effective use of the reservation. Now it's talking about the reservations, not the land where a federal bank sits, or an IRS office sits, or a federal building sits. For the purpose designed, considering it has an instrumentality for the execution of the powers of the United States. Let's read that again, because instrumentality is an interesting word. That means an instrument or a tool for the execution of the powers of the United States government. And I think this is the possible expansion in our minds of the jurisdiction of the federal government over private people, which they don't actually have, using the instrumentalities. So in this case, the service of process must be allowed except where such interference in jurisdiction of the state would destroy or impair the effective use of the reservation for the purpose designed, considering it has an instrumentality for the execution of the powers of the United States government. I'm going to have to look into that more. Where the right to serve process has been reserved by a state, such process can only be the result of the acts committed outside the reservation, and obedience will be given by all persons on the reservation to such process. Okay, so when a state serves process on a person on a federal reservation, obedience will be given by the people on the reservation to the process. So the military has to comply. So it was saying in Kansas, not all jurisdiction was ceded. So in Kansas, such as, for example, on Fort Leavenworth, if a state wants to serve process on a military person, the state can come on the military lands and serve that process. Whereas in another state where the state did not keep that jurisdiction for itself, then they cannot go on that post and serve process. They have to go through a federal court. And this is a part of the Constitution where they talk about the courts used by citizens. Where the right to serve process has been reserved by a state, such process can only be the result of acts committed outside the reservation. So what it's saying here is a military person can go off post. Okay, they have something called liberty, and when they go on liberty, they're allowed to go off post. They can go into a local bar and have some drinks. Well, sometimes when they go into these bars, they make trouble, damage property, do bad things. And when they run back to their military posts, the people who are injured, or the person who is injured, has a right to go to the courts and have process served on that military person, to have them come back off post and pay for whatever they've done. Where it amounts to an arrest of a military person, the commanding officer will permit him to be removed by the civil power unless at the time he be waiting trial by a military court or serving a sentence of the same. So, for example, if a military person comes off post, commits a crime, goes back to post, and the crime is against the Code of Military Behavior, the UCMJ, Code of Military Justice, then he also has to serve in a military court. So he could end up serving state and then military. And in some cases, the state will allow the military to do that, to take care of that for them. In this case, the commanding officer will inform the civil authorities of this fact and decline to surrender the prisoner. The civil authorities should receive notice, however, of the expiration of the term of confinement and the soldier in order that they may take such measures after his release to vindicate the law as they see fit. So if a military person comes off federal lands into a state and commits a crime and goes back to the post, and the post knows that he committed the crime, the military will bring him into a military court and put him into a military or federal prison, and he'll serve his time there. When his time is up, they will hand him over to the state, and the state will take possession of that person, and then he will stand for the state crime. Where the process takes the form of a writ of subpoena or of a summons to appear before a court, a commander should assist the court by granting permission, if need be, to an officer or soldier to absent himself from the command in order to comply with the process, or in the case of a prisoner who is needed as a witness, by sending him when he is wanted under proper guard. So the thing that comes to mind right now is you have agents of the federal government who come off federal lands and charge civilians with federal crimes. Like, for example, this IRS scam that they have going on with the corporations. So that would mean that these agents are part of the instrumentality, not the one mentioned above here, but the instrumentalities created by corporations that are sucking people into signing these, what appears to be these federal contracts, which are forms that they ask you to sign to pay taxes to the federal government, to which any person not on federal lands doesn't actually have to pay, because the Constitution applies to the federal people on the federal lands. And then the laws of the United States are the laws, the ways in which they carry out the Constitution. So it's sort of like a general law and then a law on how to carry out those laws, more specific ways to carry out those laws, such as all the things we're reading here. It says, like authority on reservations or military posts. But they differ from state to state because every state has claimed a different level of jurisdiction on the federal lands. A civilian may legally be arrested without a warrant, as well as a military person, as by any citizen where he commits a felony or a crime in breach of the public peace in such person's presence, or where a felony having been committed, such person has probable cause for believing that the party arrested is a felon. In a case of such an arrest at a military post, the arresting officer or soldier should use no more unnecessary violence, should disclose his official character and inform the party of the cause of his arrest, and should deliver him as soon as reasonably practical to a civil officer authorized to hold and bring him before a court or magistrate for disposition. Now remember, we're on a military reservation. So what does this mean? When a civilian, because in some situations, civilians are allowed on military posts. They're allowed to work there, and so they're given a card and a pass, and they can come on when they need to. Or civilians who are not working with the federal government, for example, sometimes the federal government has events such as fireworks on the 4th of July or other things. And you also have officers' dependents who are civilians who are called dependents, such as what you see on the IRS form, who are allowed on military posts. Now, when a civilian of any of these type go onto a military post and commit a crime, they may legally be arrested without a warrant, as well as by a military person, as by any citizen where he commits a felony or a crime in breach of the public peace in such person's presence. Now, it's still talking on military reservations, the public peace on military reservations. Or where a felony having been committed, such person has probable cause for believing that the party arrested is a felon. So if you're off federal lands and you come across someone and they're like, oh, the federal people are wanting you, they have a warrant for your arrest out, they have your picture on a poster, I'm arresting you. In that case, that can happen. So you can't commit a crime on a federal land, run off the federal land, and think that you're not going to get arrested. You can still be arrested. So in the case of such an arrest at a military post, the arresting officer or soldier should use no more unnecessary violence. So arresting officer, the police, or soldier. So officers normally in the government are uniformed officers, military uniform, not police officers like we see in the state. But we do have police officers and they do make arrests. So I'm not saying they don't make arrests. I'm saying that I don't believe that this document here is talking about the police officers of the state. Because officers from a federal standpoint are normally commissioned officers. Civil officers, such as ministers and ambassadors, are also commissioned officers. Okay, so the arresting officer or soldier should use no more unnecessary violence, should disclose his official character and inform the party of the cause of his arrest, and should deliver him as soon as reasonably practicable to a civil officer authorized to hold and bring him before a court or magistrate for disposition. So as far as I'm concerned, when I read this stuff, I do not see anything in here that states that a civilian minding his own business, driving his car down the road, highway or whatever, can be stopped and arrested by any arresting officer or soldier or ticketed or anything else because he's not acting in a public sense and he hasn't breached the public peace on a military post to which the federal people have jurisdiction only on those federal places, those federal lands. Where the crime is committed on a reservation by a civilian, he should at once be arrested and turned over with the statement of the case to the nearest civil authority for trial by the federal courts because he committed a federal offense on federal lands, not a federal offense off federal lands because he's a civilian not on federal lands. Now, if he's a civilian off federal lands and he commits a crime, let's try to reason this out. If he's a civilian and he commits a crime off federal lands, he's not under federal authority. He's under the civil authority of the state. When an agent or a so-called officer, modern time, comes off the federal land to arrest someone for committing a federal crime when they were never on federal lands, there is no constitutional authority for that. Now, if he interacted with an agent transporting gold and silver and stole the money from him, then yes, he will be arrested in that case because he's interfering with the federal business. But speeding is not interfering with the federal business. And I'm not condoning speeding. I don't think people should speed. I think they should obey the laws, but they should do it voluntarily. He may be held in the guardhouse for only such intervals as may be absolutely necessary. Where a soldier commits murder, a crime not punishable by court-martial in time of peace, on a military reservation, he may be confined in the guardhouse until, after communication with the nearest United States attorney, he shall be turned over to the civil authorities. So here we have an indication of wartime law and peacetime law, where the federal government does not have authority to punish for certain crimes during peace. Okay, so we need to keep that in mind when we're reading these things. Okay, I don't want to read all of this, the writ of habeas corpus. A writ directed to the person detaining another and commanding him to produce the body of a prisoner at a certain time and place, with the day and cause of his caption and detention to do, submit to, and receive whatsoever the court or judge awarding the writ shall consider on that behalf. The writ has many variations and issues for a number of purposes. We are only concerned with the case where the writ is issued to an officer and affects the body of one lawfully held. Now, you see earlier they used legally arrested. I just want to point that out to you. Lawfully held by military authority. In all cases where the writ is served, the officer to whom it is addressed will make a respectful return. If the writ issues from a federal court, that's where we get, the civilians and citizens of the state or the federal government and their relationship to each other when it involves some federal issue, not for just some arbitrary thing. Or judge, return will be made and the person held produced at the time and place required. If the writ issues from a state court or judge, the person will not be produced, but return will be made, giving the reason for not complying with the writ. As the question is fully treated on the manual of court-martial and forms for the returns given, it is unnecessary to go more deeply into the matter in this article. So when we're looking at the Constitution, we're looking at, in my opinion, the ways in which the federal government is supposed to act during war and peacetime because it's basically all military. Taxation. An officer or soldier of the army, though not taxable officially, may be and often is taxable personally. So we're not in the military, most of us. He is not taxable by a state for his pay. Now we're talking about federal taxes. Who pays the federal taxes? What goes on? The state cannot tax federal income. So the federal government cannot tax private income unless he's an officer in the military. He's not taxable by a state for his pay and for the arms, instruments, uniform, clothing, or other property pertaining to his military office or capacity, but as the household furniture and other personal property, not military, he is. Okay, so we're talking about a military person bringing his private. Okay, so let's look at this for a second. My understanding is that when a person wants to join the military and become an officer, they have to leave the state and join the military and become, quote, a citizen with a capital C of the United States. When they do that and they bring their personal property onto a military reservation, they pay a tax on their property. Equally subject other residents or inhabitants to taxation under the local law. On the other hand, those who are exempt from taxation as dwelling in places under the exclusive jurisdiction of the United States are not entitled to enjoy any of the privileges of the citizens of the state, such as the privilege of voting or the use of public schools. Okay, so this is your taxation thing. This is who is and who isn't, where, when, how, why, what. So if you work off federal lands and you are not associated with the federal government, you do not pay a federal tax. It doesn't make any sense to pay a federal tax. But if you go and you sign papers and you contract with one of their instrumentalities and you say, sure, I'd like to pay a federal tax, then you are paying a federal tax. If you go to apply for a job and the job wants you to sign the paper and pay a federal tax, then that's on you. You signed the paper. An officer or soldier of the army, though not taxable officially, may be and often is taxable personally. He is not taxable by a state for his pay or for the arms, instruments, uniform, clothing, or other property pertaining to his military office or capacity, but as the household furniture and other personal property, not military, he is. And I believe this is really the customs, the imposts, the excise. So you pay a tax on the stuff you bring in, you pay a tax on the stuff you take off the federal lands, customs. Okay, all of that I believe is pertaining to the things coming onto federal lands and the things going off to federal lands. Not private people. Equally subject with other residents or inhabitants to taxation under the local law. Okay, so the state can, I think they're saying the state can tax the things a federal person is bringing off federal lands. And when you get into the intoxicating liquors and the marijuana and all these other laws, quote laws, they apply on the federal lands. On the other hand, okay, so also I like to place in here that sometimes there are private people living on federal lands who owned some lands and didn't want to give it up to the federal government because they had a allodial title and had been in their family for generations. They become sort of quasi-federal state people, but because they don't actually live in the state, they don't participate in state things such as voting. They can't send their children to a public school. And the officers were not supposed to send their children to public schools because they don't pay state tax. Citizenship, an officer or soldier does not lose his citizenship by entering the army. However, he subjects himself to trial without jury for any military offense. So it's talking about state citizenship here. And he may forfeit the privilege of voting depending on the state of his domicile. He also surrenders for the time being, as far as the military service may require, his right to personal liberty. So he does not lose his citizenship. He gains a new citizenship of the United States. And if you go to USA Jobs, it used to require people to be a citizen of the United States or United States citizen to even be a civil servant, which shouldn't be the case. Now it seems like they're just saying, well, you just got to take an oath. Residence and domicile. What is meant by residence of a person in the military service depends entirely upon the kind of residence contemplated, whether it be residence for voting, for divorce, for process, for homestead rights, for schools, privileges of schools, for taxation, for questions on probate. So this is a good time to read or look at something here. I'll search this, then get back to it. No, here it is. That's chapter 2. I think this is chapter 1. Here we go. So here's jurisdiction over federal areas within the states. This is this book here. Jurisdiction over federal areas within the states, reported the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the States, Part 1, the facts and committee recommendations. This was put together by Eisenhower, started in 1953, Part 1 published in 1956. This is Part 1, Chapter 1. And by 1950-something, it's almost as if they had already been confused about what everything Lincoln had done, and the confusion between what is and what isn't as far as their authorities. So the study was of a group of school children on the federal lands. So they're dependents, they're dependents of the federal people, federal employees residing on the grounds of a Veterans Administration hospital. They wanted to send their children to the public schools, and they were told no. They took it to a local court, and the local court said no, because you're not residents in the state. You don't pay state taxes. Why should we let you use our state public schools? Because you have a federal tax. You need to go build federal schools. And the state had ceded exclusive legislative jurisdiction over the areas. And then they took it later to the state Supreme Court decision with a view toward applying to the Supreme Court of the United States for a writ of certiorari. The Department of Justice ascertained that state laws and practices relating to the subject of federal legislative jurisdiction are very different in different states. So it was different for each state. That's the comity, which is respect of the various jurisdictions. So you have state jurisdiction, you have federal jurisdiction. You have some states kept a lot of jurisdiction over the federal areas. You had some states didn't keep any. Okay, so that's what it's talking about. Whether or not children of military people or civilians working on a military reservation who are resident on the military reservation, even such places as the veterans hospitals, because back in the old days, they actually lived there because they became citizens of that place and they lived and worked on those lands. By 1917, the whole idea of living permanently on a military reservation was changed, and so they were allowing more of a public-private thing, and then some states allowed it more and some states allowed it less. So they're trying to figure out, and they've been trying to figure out the jurisdictions of each of these things for each of these states. So whether, for instance, an officer or soldier stationed at Fort Leavenworth, Kansas, because Fort Leavenworth has a different type of jurisdiction, it's not exclusive. That means the state maintained some level of power over the federal area. So a soldier stationed at Fort Leavenworth, Kansas is a legal resident of Kansas for any of the purposes stated or for any other particular purpose. Depends on the laws of the state of Kansas. The domicile for an officer or soldier who entered the service at or after majority is the same as the one he had when he entered the Army, provided, of course, he has not in the meantime changed it. A person in the Army can neither gain nor lose domicile by reason of his presence or absence while in the service. So when they're sent somewhere else, they don't lose their domicile. Of course, any officer or soldier who wishes to change his domicile may do so. But acquisition of a new domicile must be accomplished by a voluntary and positive act. Okay, that's important. A voluntary and positive act. He must have done it himself. He must have signed something. He must have come forward and said, oh, I want to do this. Just like when you sign the W-4 to have the taxes taken out. It's a voluntary and positive act. That is by taking the proper and appropriate steps to do so, always bearing in mind the fact that the question of domicile is one to be regulated by state and not federal law. Okay? Talking about dress, talking about military things off federal lands, unless it's not protected information. Necessary knowledge. The adjunct general has to have certain knowledge. War Department Army regulations. Customs of the service affecting adjuncts. Okay. Cheerfulness, harmony, contentment, important factors of discipline, and efficiency of a command. Musicians. And I've read some stuff that makes it appear as though orders are just an arrangement of people. Let's see, here's orders, just happen upon it. Orders are numbered serially beginning with the year of the establishment of the new command. It is customary to note on the first number of a new series the last number of the preceding series. The GO number 192 is the last of the 1904 series, would be noted on the first of the 1905 series. Whenever a corrected order is issued, the following should be written on the top of every copy. Corrected copy, please destroy. Copies previously sent. If for any reason a serial number should be skipped, i.e. the order be not issued, it is customary to publish a skeleton order so as to make the file complete. For example, if GO number 52, Headquarters Department of California, should not be issued, the following would be published. Headquarters Department of California, General Orders number 52, not issued. Because the military is all about uniformity, completeness. Special orders, extra duty. So special orders are for a particular person. When they are moved from one post to another, they're called special orders. The president's supposed to issue as commander-in-chief general orders. General orders over the military. Which would include all military personnel, such as a day off of work, such as what Washington did, I think was his first order. So some of these instrumentalities are used to help the feds achieve certain tasks on federal land, such as Department of Labor or the OSHA department, environmental departments. All those things are instrumentalities used by the military to help do military things. And you can be a part of it if you just sign their forms. And the forms go through the Reg Info website, and also through the Office of Management and Budget. And that's how they extract money from the private people to which they have no right to tax. So this is a good book. It took me a while to find it. I was looking for something like this. This is one of the few I found. I'm sure there's more out there. And these are really interesting to read because they really show you the difference between what the federal government can do, what it can't do when it talks about their officers, their agents, their roads, their jurisdiction, their force, their power. All that stuff applies for the most part on the federal lands only and over the federal people. And they're restricted. They're not supposed to come off the federal land. So these officers, these so-called officers that may have a federal private capacity, which, okay, I should say public-private capacity, acting as officers with any sort of power or authority off federal lands, to come to get you or to come to make you do something or threaten you, they don't have any power to do that. And most likely they work for an instrumentality, the public-private people. And those instrumentalities are supposed to do the work for the federal government. But no one has to perform any voluntary or positive act to come under their power, to come under their jurisdiction. This is in Chapter 2, History and Development of Federal Legislative Jurisdiction, to provide for an area independent of any state and under federal jurisdiction. So in Article 1 of the Constitution, where it says that the Congress has the power to legislate for the United States, it's talking about the federal areas. The federal areas are the United States, and it's an agency that works for the private people who are American civilians. I say private American civilians, but you can say it however you want as long as you don't say you're a citizen of the United States, because that puts you under federal jurisdiction. Outline of legislative jurisdiction. Federal real properties, holdings extensive. The federal government is the largest single owner of real property in the United States. Its total holdings exceed the combined areas of the 6 New England states plus Texas plus the value of the holdings. So not the entire country. Their combined area is 6 New England states and Texas. Those are all the federal lands. Now, not all of those federal lands are owned constitutionally, because they didn't acquire them for forts. Okay, and then the state had to give up the land in the first place and jurisdiction. Okay, so there's this is another video for you to put in your arsenal for whatever you want to do if you want to do anything at all, or just to understand what is going on here, what's the truth. And if you have any questions or comments, please consider leaving them. Also, like, share, and subscribe. I really appreciate it when people share my videos, because I have a very, very difficult time advertising the information and getting people to find my channel in the first place. So again, this is the Officer's Manual by Major James A. Moss, 24th U.S. Infantry, 5th edition, revised and enlarged, printed April 1917. A service manual. Okay, now the military has a lot of libraries for military use on the federal lands. I was at the one in Fort Leavenworth. It's huge. It's enormous. This is archive.org, details, officer's manual. You can write this down and check it out. Go through and read it. If there's something you don't understand, consider looking up these two books, which I have also posted on archive.org. There's part 1 and part 2. As well as there's one other book that tells you how to understand the jurisdictions by code, by jurisdictional code. Let's see. It's called, it's on my, I'll post a link. That'll make it easy for you. So like, share, and tighten there.